Welcome back at another video class on an important topic uh, that is Foreign Contribution Regulation Act 2010, FCRA in short. It is very important for exam point of view and of course practical point of view. FCRA was recently, in fact 2010 they had replaced the entire law. Foreign Contribution Regulation Act 2010, which is part of your economic law topic or the allied laws topic, which is very interesting and very important too. And few students feel it difficult to differentiate this law with FEMA. FEMA, as already told in my earlier class, FEMA deals with foreign exchange transactions, but here the core concept is restrictions on accepting foreign contribution and foreign hospitality from a foreign source. Don't forget these three terms in FCRA. One is foreign contribution, two foreign hospitality, and third one is these two, foreign contribution and foreign hospitality comes from a foreign source. The law in nutshell prescribes restrictions on accepting foreign contribution, foreign hospitality from a foreign source. So we'll be dealing in detail. Objectives of FCRA: to regulate the acceptance and utilization of foreign contribution for hospitality. I told you just before that this law is, the crux of this law is restrictions on accepting foreign contribution or foreign hospitality. Not for all, for certain classes of people or certain classes of associations or companies to regulate this concept. So this is the objective. I'll read again: to regulate the acceptance and utilization of foreign contribution or foreign hospitality by certain individuals or associations or companies, and to prohibit acceptance and utilization of foreign contribution or the foreign hospitality. So basically it's regarding to two things. One is regulating and second one is prohibiting. So this is the crux of this law. This law is basically about regulating the acceptance or prohibiting the acceptance of two things. What are the two things? Foreign contribution or foreign hospitality. Mind you, the both comes from foreign source. And the crux of this restriction is basically national interest. The crux or the core of why you restrict foreign contribution or why you restrict foreign hospitality, because in order to protect our national interest. So study plan starts now, and you have to be thorough with some definitions in this law. I will just give you the snapshot of the definition which you have to study. Association 2.1a, foreign contribution 2.1h, foreign hospitality 2.1i, foreign source 2.1j, and person 2.1m. These five definitions, especially this four definition, is the core of this law. So every student is supposed to read these definitions very specifically, very detailed, and make it very thorough, because practical questions will be mainly focused on the conceptual aspects, especially with regarding to the foreign contribution and foreign hospitality. So before opening up the study material, before opening up any private material you have or any online classes or offline classes you attend, it is better to understand the intricacies of these definitions, especially foreign contribution to 1H, foreign hospitality to 1I, foreign source to 1J, and of course person to 1M. Don't forget to study that. Now we will be further sections which you have to study. I have listed in the slide. These are the study plans, so please take down in your notebook or your whatever thing you have. Apart from definition, you have to study section 3, the prohibition of foreign contribution; section 4, exemption to foreign contribution; section 6, restriction on foreign hospitality; section 7, prohibition of transfer; section 8, utilization; section 9, power of central government to prohibit receipt of foreign contribution. Don't forget that, just you copy this slide and keep it, because we are going to have an elaborate session on these different provisions. And the third category of sections you have to study is section 11, registration; section 12, grant of certificate registration; section 13, suspension of a certificate; section 14, cancellation of certificate; section 16, renewal of certificate. And this study plan 3, that is this bunch, wholly deals with registration formalities. So this is also important for exam point of view and for practical advisory point of view. So these are the bunch of two sections which you have to study, and you have one more bunch to study. This is with regard to appeal. Every law, that there is some appellate provisions. Here it is appeal to Court of Session or Honorable High Court within 30 days, section 31. Then punishment for contravention, section 35, which the punishment of FCRA Act is 5 years imprisonment or fine or with both. I repeat again, section 35, punishment of FCRA Act is imprisonment for 5 years or fine or with both. Then offense by company, in most of the law you have, and of course section 41 composition. So the last 3 slides which we have discussed is about the bunch of sections you have to study. That is the overview of this chapter. I'll repeat again. Definitions, 1 bunch, okay. 2 main provisions, section 3, 4, 6, 7, 8, 9. Then with regard to registration, that is 11, 12, 13, 14, 16. Right. Then with regard to applied provision, section 31, 35, 39, 41. Especially 35 is important, penalty. Any person who any association of person who contravenes, the provisions of FCRA will be penalized for imprisonment of 5 years or fine or with both. So this will do the overview, 1, 2, 3, 4, 4 slides, definition. Then regarding to the charging sections, section 3, 4, 5, 6, then you have to go to, before you go to the, prosecution area, you have something called as the registration. Then you have to go to the appellate provision, especially penalty. So these are the basics of the overview of this FCRA Act. You have to study this, at least these bunch of sections. Now we will go into explaining these topics, right? First I will teach you about foreign contribution. What is foreign contribution? As already referred, section 2(1)(h) is the definition, and section 3 is the prohibition to accept foreign contribution. I repeat again. Definition section is 2(1)(h), and charging section, that is the prohibition section, is section 3. What is foreign contribution? Foreign contribution means a donation, a delivery, or transfer. What are they? Foreign contribution means a donation, the delivery, or transfer. Short form is DDT, right? DDT. DDT is the charging. What is that? Foreign contribution means a donation, a delivery, a transfer made from a foreign source. As already told, everything should come from a foreign source. Now, what are the matters which is included? One is article. Article, thing, anything, article. There is an exemption for article. Article not being an article given to a person as a gift for his personal use. So personal use gifts are exempted. Like, you have a VCR, you have a camera, you have a DSLR camera, you have a mobile, you have a smartwatch, you may get some mobile phones, you may get some, wearing rings or bracelet, a pen, a gift box, etc. So, mind you, an article is clearly a foreign contribution, except those articles which are in the nature of gift, and that too for a personal use, right? But the market value of the same in India should not exceed rupees 25,000. Mind you, practical question area. This 25,000 is introduced in FCRA Amendment Act 2012 with the form 1204/2012. So the first charging is with regard to article. What is a foreign contribution? It's basically a donation, delivery, transfer. What is the donation, delivery, or transfer? It may be an article, but the article has an exemption. What is the exemption to an article? Exemption to an article is any article for gift purpose, that is for personal use, is exempted. For that, there is another bracket that the value of the same should not exceed 25,000. If it exceeds 25,000, then the exemption will be lost. Gift personal use exemption will be lost. So the maximum limit of an exemption to claim a gift or for personal use is up to rupees 25,000 in Indian value, and that value is fixed in 2012. That is 12/04/2012. Don't forget that. So don't forget this value. The gift for personal use is exempted under the category article only if the value is less than rupees 25,000 in Indian value. Second one is currency, either Indian or foreign. It is basically a foreign contribution. Any foreign security, that is a security with the meaning of FCRA Act or within the meaning of FEMA. So that's why I put in bracket FCRA and FEMA. So these are the 3 categories of foreign contributions which we are talking about. Section 2(1)(h). Right, with section 3 says that what do you mean by foreign contribution? What is foreign contribution? Foreign contribution means a DDT. What is a DDT? Donation, transfer, or delivery. Donation, delivery, or transfer. The 3 articles, 3 things which are been stated. One is an article, but exemption. What is exemption? For personal use, a gift is exempted. But there is a limit for that. The value should not exceed rupees 25,000. Right. Second one is currency, Indian or foreign. Third one is security. The term security as defined in FEMA or as defined in the FCRA Act. So this is the starting point of foreign contribution. You must now understood what is a foreign contribution. Mind you, this foreign contribution should come from where? It should come from, it should come from a foreign source. Now explain further. There is an explanation to section 2(h). This is very important, which says like that. Explanation 1. Either directly or through one or more person. It is very important that a foreign contribution will be attracted as a foreign contribution even if it is accepted directly or through other person. So directly or otherwise, directly or indirectly, the person receiving the foreign contribution will get attracted under the FCRA Act. Second one, the explanation is interest thereon should be deemed as foreign contribution. If a money is from foreign source, for example, say X number of US dollar, you are put into it in an FD in your bank account, obviously an interest will be earned. That interest portion will also be considered as a foreign contribution. Third one is exemption here, very important exemption here. Apart, already you have an article for personal use, that is for gift for personal use, and exemption is there up to 25,000. The next exemption is in explanation 3, which says that fee and education fees. It's like, fees for education purposes, for that is exempted. Second one is or towards cost in lieu of goods or services rendered in ordinary course of business, trade or commerce. For example, you had given an online class, or say you had sold a book to a foreign person, a book or a particular thing. That is an ordinary course of your business. You are a writer, you are a publisher, you had sold something to a foreign party, he will be paying for the same. That is exempted because that is not a foreign contribution ipso facto. It is a payment in lieu of a goods or services you had made. So very important, explanation 3, don't forget, if you are giving any service or goods in the ordinary course of business to a foreigner or to a foreign source and he pays, the foreign person pays you in turn, that payment cannot be regarded as a foreign contribution because that is a payment in lieu of goods or services rendered by you. Got it? So this is very important 2 slides. I explained about what is foreign contribution. DDT, don't forget, that should be come from a foreign source. Don't forget, there are 3 listers. Article, there is an exemption for article for personal use 25,000. Don't forget currency, then foreign security. Then you have to study 3 explanations. 3 explanations is very important. One is directly or indirectly. Second one is interest portion. Third one is exemption. Got it? Now a few more interpretations I am adding that because the goods or services is very important. I am asking here a question answer mode, which is basically from the website of interpretation is taken from the website of the Ministry of Home Affairs, MHA. Here it is, whether earnings from foreign clients by way of a person in lieu of goods or services rendered, it is to be treated as foreign contribution. I told you again and again, any payment in lieu of goods or services made by you to a client in a foreign nation is exempted. Because why? That is not a foreign contribution. Answer: no, foreign contribution excludes earnings from foreign clients by a person in India. In lieu, why you got it? In lieu of goods sold or services rendered. You had sold some goods, you had given some services to them. If you had given some goods or services to them by the ordinary course of business, it is a commercial nature, and that payment given by that person, that is your buyer of the service receiver, is exempted. I will make it this slide very simple. Again I am saying I am an author of a book. Say otherwise I am having a platform or a software which is uploaded in a site that has been bought by a foreigner. He is a foreign source, right? And he is paying for example, he paid $250 for that software which you had developed. It is clear case of an exemption. Because why? It is commercial in nature and cannot be treated as foreign contribution. Whether it is a foreign contribution, he is want to help you. No, he has given you that money in lieu of goods or services rendered by you. Got it? Don't forget that. Friends, now we are going to the charging area where section 3 says about this is the very important crux. Many students has got confusion that whether foreign contribution can be accepted or not. I will say like this: foreign contribution is restricted for certain persons listed in section 3. Don't forget, foreign contribution is restricted or banned for certain persons restricted in section 3. Other than section 3, for example, like this, having a definite cultural purpose, economic purpose, educational purpose, religious purpose, social program, can receive foreign contribution. Don't forget it. Students get confused whether foreign contribution banned or not. Yes, accepting foreign contribution is banned. It is prohibited for certain persons only listed in section 3. Apart from the persons listed in section 3, genuine buyers, genuine receivers who have a definite cultural, economic, education, religious or social program can receive foreign contribution in two ways. One is by obtaining prior permission from the central government by filing form number 3B, or by getting registration with the central government by filing form 3A. Don't forget it. I repeat again, foreign contribution receivers is divided into two categories. One is banned list, prohibited list. They should not receive foreign contribution. That is stated in section 3. Second one is permitted list. Who are the permitted list? Who have definite cultural, educational, economic, social, religious, social programs in hand. The association who conduct cultural programs, so and so, so the list. They can accept foreign contribution two routes. One is by obtaining prior permission from the central government. The form used is form 3B. Second one is having a permanent registration with central government by having form number 3A. Don't forget this slide. This is essential, right? Now you may ask, sir, what are the prohibited list? Section 3 speaks about prohibited persons or associations which should not accept foreign contribution from a foreign source in any case. Section 3, don't forget section 3. In slide, these are page numbers, right? Here is sections code. Section 3, a candidate for election, a correspondent, a columnist, cartoonist, editor, owner, printer, publisher, registered newspaper, judge, honorable judge, government servant, employee of a corporation, or any body corporate owned by the government, political party or office bearers of political party. The list continues. Organization of political nature, association engaged in the production of broadcasting of audio news, audio-visual news agencies, that is the TV channels, online channels, etc. Correspondent, columnist, cartoonist, editor, owner of association of persons. So students, you must read section 3 very, very in detail and must take the list, because practical question will may ask, or in practical consultancy you will be in trouble to advise your client that whether this person in front of you is in the prohibited list or not. For that you have to study section 3 in detail. The list, you have to study this whole list, list 1 in this slide and list 2 in this slide you have to study. You may well understand that the prohibited list persons are dealing with public. Am I right? These persons are dealing with public at large. So that is why the law has put restriction. I repeat again, restriction of foreign contribution is stated in section 3, which says that the list which is stated, the persons or association stated in section 3 cannot accept any foreign contribution from a foreign source. Got it? The other category, don't forget, there are certain categories who can accept by way of prior registration with the central government, form 3B, or prior permission from the central government, form 3B, or by way of registration with the central government, form 3A. That is stated in the early slide. Don't forget about that. Now, a golden exemption, section 4, which speaks about a general exemption. Don't forget and don't confuse. Section 3 prohibits acceptance of foreign contribution from a foreign source by persons restricted, right? Section 3 gives open exemptions. What are the open exemptions? Even this section 4, don't forget, section 3 is restricted list. Section 3 is restricted list, right? Section 4 is general exemption. And section 4 is applicable to section 3 also. Those persons who are restricted to receive any foreign contribution, like honorable judge, government servant, candidate for election, political party, political natural party, etc., which you had listed earlier, even they can accept foreign contribution if it is attracted under section 4. That is general exemption. What are the general exemptions? Payment by way of, contribution by way of salary, wages or remuneration. Payment by way of international trade or commerce, payment by way of gift or presentation, payment from his relative, for example, a judge, honorable judge, or a government servant, say there is a government servant, his wife or sister or brother or his son may be in the United States of America, may be in London, his son may send some gift to him, some money to him, some gift, some articles to him, whether it is attracted, no. Why? Even though the government servant is attracted under section 3, the restricted list, the gift from a relative, that is from his son, is exempted, because why? Section 4 gives you general exemption. So students, don't forget about section 4, which gives general exemption from practical point of view, and for exam point of view, practical question may be asked. Section 4 speaks about exemption from, by way of giving that money or the gift is by way of salary, wages or remuneration, on account of international trade, by way of gift or presentation from a relative, don't forget that, by way of remittance in official channel, and by way of scholarship or stipend for a student. Don't forget, this slide is $1 million slide because section 4 is an exemption to section 3. Practical interpretation, this is very important slide, because institute may ask a question, and for a practical purpose, while you advise your clients or nearby friends and relatives also, there may be a question that whether a foreign contribution received from a relative is exempted or not. I will read the interpretation. Whether foreign remittances received from a relative are to be treated as foreign contribution as per the FCRA Act 2010. Answer: Section 4E of FCRA 2010 and read with Rule 6 of FCRA Regulation 2011. Section 3, prohibition is not applicable where the foreign contribution is accepted from his relative. This is very important. But I like to invite your attention to Rule 6 of the FCRA Regulations 2011, which says that the relatives, there is an exemption limit, that is if the amount of contribution received from a relative in a financial year is in excess of rupees 1 lakh, then that information has to be informed to the central government in Form FC1 within 30 days of receipt. Don't forget that. I repeat again. However, in terms of Rule 6, any person receiving foreign contribution in excess of 1 lakh or equivalent thereto in a financial year from his relative in excess of 1 lakh in one financial year from a relative, that is exempted. Any foreign contribution from relative is exempted, we know that. But if the amount is above rupees 1 lakh, then you have to give an intimation to the central government that we have to receive this much article, this much amount, this much currency from a foreign relative. Don't forget that receipt of foreign contribution from a relative is exempted, we know, Section 4E. But if the amount in a financial year exceeds rupees 1 lakh, it is the law under Rule 6 that you have to give an intimation about such receipt to the central government in Form FC1 within 30 days of receipt of such contribution. This slide is very important. Don't forget, for practical purpose and for your practical questions for exam purpose. So I'm continuing, students. Again, an interpretation which I already asked you about delegation, participation fee, etc. These type of fees, education fees, delegate fee, etc. is been exempted under the FCRA because no permission under the FCRA is required, because the intention is not foreign contribution. The intention is it is by way account of a fees or by account of a delegate fee or by of a participation fee. You must understand the intention behind the law. The intention behind the law is the restricted person under Section 3 should not get any benefit, any advantage, any undue gain from a foreign contribution from foreign source. That is the law. But if it is a genuine contribution, genuine salary, genuine international trade payment, genuine from the relative, genuine transactions, then it has been exempted by various interpretations and by Section 4 ipso facto. Again, whether can foreign contribution be received in rupees? Yes, any amount received from foreign source in rupees or foreign currency is considered. So it is immaterial about the currency. If an FC, that is foreign contribution received in Indian currency or in a foreign currency, both will be attracted under Section 3. Don't forget that. Interest portion, I already told, if the income, not only the income or foreign contribution, the interest portion attached to that will also attract FCRA Act. So this slide speaks about two interpretations, which is the currency which is been attracted. Whether FC is in Indian rupee or whether FC is in foreign currency, that will be attracted. The second question is whether interest portion of that amount will be attracted. Yes. Again, the interpretation continues. Can an association invest the foreign contribution received by it in profitable ventures? If, for example, I told you, there are some associations for social, cultural benefits or religious purpose, they are permitted to receive foreign contribution. They are not in the ban list. They are permitted to receive foreign contribution by two ways. One is by prior permission or two by way of registration. Form 3B and 3A. You may remember that. Now, the question is whether that amount received from the society, from the association, whether the amounts received by the association from a foreign source can be invested for profitable ventures, can be invested for a speculative business. The answer is no. The amount received from the foreign contribution by such association should be used only for the purpose for which it is been bought back, for only for those purposes for which you had been received that, or for any purpose for the furtherance of the object of the association. You should not invest that in profitable ventures. You should not invest that in speculative business like share market, investment, mutual fund, etc. Can foreign currency be mixed with local receipt? No. See, for example, for in a year, an association has got, say, 10 10,000 US dollar from America for the purpose as a foreign contribution. You may got some other, say 25 lakhs from a local friends or local association from India. The question is whether this two, one is foreign contribution, one is Indian contribution, can be deposited together. Answer is no. The foreign contribution received should be kept in a separate designated bank, and Indian contribution received should be kept in a different bank account. I think I told maximum with regard to foreign contribution. Students, the first part of our discussion is over now. We have been discussing about foreign contribution. I told you about the definition of foreign contribution. Don't forget about DDT, right? Don't forget DDT and the three things: articles, currency, and security. In article, you have an exemption for a personal purpose gift up to 25,000. Don't forget. Then we explained about three explanations: explanation 1, explanation 2, explanation 3, with regard to the commercial transactions, etc. Then we told about the restricted list in section 3, which is a list is there: candidate for election, political party, political purpose, honorable judge, government servant, etc., etc. Then we discussed about section 4, which speaks about general exemptions. Then we discussed about few interpretations in that. Don't forget about that. Now again I am coming to, because after this we will not discuss about foreign contribution. So I am saying that foreign contribution regulations or foreign contribution restrictions divided into two categories. One is banned, prohibited list, section 3. Second one is allowed, that is associations for social, religious and cultural systems, right? Cultural promotions. There also there are two types. One, they can accept foreign contribution by prior permission with the central government. Two, by prior registration with the central government, form 3B and 3A. And don't forget the exemption with regarding to relative. It's very important for practical and exam point of view, relative. But there is another exemption for relative. Don't forget there is another restriction for relative. If the relative contribution from foreign relatives is exceeds 1 lakh in a year, then you have to give an information to the central government in form FC1 within 30 days of receipt. So I am culminating. Now I am stopping my foreign contribution discussions and teaching. Now I am moving to foreign hospitality. Students, there are two categories. In the opening remarks itself I told FCRA Act is about restriction with regarding to one, foreign contribution, and second is with regard to foreign hospitality, and that both comes from foreign source. Now we move to foreign hospitality. Basically, what is foreign hospitality? Foreign hospitality means good manners. Hotel stay, right? You have giving education facility, giving lodging facility, giving you food, giving you travel, medical facility, tour, travel, etc. So what is hospitality? Hospitality is making you happy various way. Not in foreign contribution, giving an article, giving some money, giving some security. Foreign hospitality, giving some facilities. So what is foreign hospitality? Section 219. Foreign hospitality means any offer not being a pure casual. One or two casual incidences are exempted. Made in cash or kind, maybe in cash or kind. Don't forget it is coming from a foreign source. What are the things you are being given with cost of travel? That is tour. Like cost of travel, that you are cost of travel to the foreign country, you are giving with free boarding, you are giving the facility with free lodging, you are giving facility with free transport, medical treatment. Don't forget. So if you ask me, sir, what is the difference between foreign contribution and foreign hospital? In one word, foreign contribution is an article contribution, a currency contribution, or a security contribution. Foreign hospitality is contribution in the nature of facilities that may be represented in cash or kind. You are getting free travel ticket, you are getting some tours facilities, you are getting medical treatment freely, you are getting some lodging. What is the difference between boarding and lodging? In boarding there will not be there will be food also. In lodging only you can stay and sleep well, you will not get any food. A lodge having food facilities or restaurant facility is called, or eatery facility or canteen facility is called as a boarding. So basically foreign hospitality is giving you facilities. Don't forget giving you facilities with regarding to lodging, boarding, traveling, transportation facility, and tour and medical treatment. I will give you here one very important thing. Foreign hospitality is not restricted, is not banned or prohibited. Here there is only a restriction for this. So what is a restriction? Section 6 says that no member of parliament, MLA, office bearer of political party, honorable judge, government servant, employee of a corporation, while visiting country or territory outside India, except with the prior permission of the central government, any foreign hospitality. So the law does not say the prohibited way. The law says a prohibited list of persons, that it is in the slide. And the law says that these prohibited list of persons who are dealing with the honorable public, who are dealing with the public at large, who are into the public domain, should not accept any foreign hospitality without the prior permission of the central government. For example, if a government servant is going to a Saudi Arabia or UAE or Dubai, and he's been awarded, he has been given with an offer of foreign, stay in a 5-star hotel by Mr. X in foreign national, he can accept that. Before traveling from India, he should get prior permission in form FC2 to the honorable central government, and central government will ask the details and so on, so the formalities, and give you permission to stay in that foreign hotel, 5-star hotel, which will be regarded as giving you a foreign hospitality. So I repeat again, section 6 says that the restricted persons in section 6 can accept foreign hospitality from a foreign source, provided they take prior approval from the central government in form FC2. FC1 is for foreign contribution, FC2 is for foreign hospitality. Don't forget that. And this is very, very, very important exemption, which is usually asked in exam point of view. What will be happening for a person who went for foreign travel, unexpectedly occurs with an immediate medical illness? So you can't expect him to give a prior, take a prior permission. You can't expect that while I travel from here to Dubai, and I can't presume that I will be made ill health and I will be admitted to a hospital. So the law is liberal, and there is an exemption. Relaxation in the case of emergent medical aid. In case of emergent medical aid needed on account of sudden illness contacted while visiting outside India, the person need not take a prior. It is impractical to take a prior approval. So here he can give intimation within 1 month of receipt of the foreign hospitality. So prior approval is not required, but subsequent intimation is prior intimation is not required, but subsequent intimation is required within a period of 1 month. And that too, intimation is exempted if the value is less than rupees 1 lakh. So if the foreign hospitality's amount is only above rupees 1 lakh, you have to, in Indian value, you have to inform the central government within 1 lakh. For example, the medical illness which you had is, say the admitted, the expenses incurred in the hospital is, in the foreign hospital, say rupees only 25,000 or 35,000 or 50,000. You are exempted to give as, you need not want to give an intimation to the central government. If the amount is above rupees 1 lakh in Indian currency, then it is duty on the person receiving the foreign hospitality as a medical aid. After receiving that medical aid, within 1 month, he have to intimate the central government. So I repeat again, foreign hospitality basically you require, prior permission from the central government, but there is an exemption for urgent medical aid. In that case, there is no prior permission, it is impracticable. You only required to give a subsequent intimation to the central government. This is very important, medical aid. Now, how do you seek permission to FH? FH means foreign hospitality. I already told that the form used is FC2. It should be accompanied by an invitation letter from those association or those person or those individual who has given you foreign hospitality. For example, if you are a friend in Dubai is asked you to stay in a foreign hotel, and he is arranging the travel, tourism, food, everything, lodging, boarding, everything, then he must give you he must give you an invitation letter, and that letter you should produce to the honorable central government, right? And of course, the permission to be seek before 2 weeks, at least before 2 weeks before your journey. For example, if you are going to Dubai or UK for a foreign visit, then at least before 2 weeks of your journey, you should file Form FC2 and get prior permission from the central government to accept for hospitality. Things are moving faster. Now that is over. Our job is over. We had studied foreign contribution in detail and foreign hospitality in detail. Now, other provisions we are going to discuss. 1 or 2 is very important. The other portions regarding to registration, etc., which is not much important for exam point of view. Section 7 says prohibition to transfer foreign contribution. See, it's simple. You need not want to accept directly. You can engage someone to accept foreign contribution, and you can ask him to transfer that to you. So that is why section 7 puts a restriction that no person who is registered and granted a certificate or obtained a prior permission under this act receives any foreign contribution shall transfer such foreign contribution to any person. you can transfer only to those persons who had got themselves permission. For example, if A has got permission to accept foreign contribution, A as an association for cultural purpose, for example, and if he receives a foreign contribution and if he wants to transfer to B, mind you, B should also have got prior permission from the central government, or he should also got a register from the central government. To put in nutshell, no person should transfer foreign contribution to any person who has not registered in this act or who has not got any prior permission in this act. Simple as that, settled law, right? Then utilization, that is not that much important. Anyway, I am just discussing about administrative purpose because there is a provision with regard to section 8. Section 8 says that no person shall utilize such contribution for purpose. Any person receiving the foreign contribution should utilize only for the purpose which you had been received. Point number 1. And I already told, the profit or the contribution or the income or the foreign contribution should not be invested in speculative business. I already told, don't invest that foreign contribution in mutual fund or speculative business. And here is a restriction with regard to the administrative expenses incurred. Shall not defray as far as possible such sum not exceeding 50% of such contribution received in foreign financial year to meet administrative expense. For example, if the association has got, for example, 1 lakh from, or say 5 lakhs or 10 lakhs from foreign source, the law puts a restriction of spending that amount for administrative expenses. If the example is 10 lakhs, then you should not spend more than rupees 5 lakhs. That is 50%, more than 50% for administrative expenses. For example, what I am intending to say here is, the law puts on restriction on utilization of foreign contribution received. What is the law? Law says you should utilize only for the purpose for which you had been receiving that. Point number 1. Do not utilize this for speculative business. Do not utilize for the administrative purpose of that project or that event or that purpose which you had been received. The administrative expenses you can make, the restriction is the up to 50% of the amount received. For example, if you receive 10 lakhs from foreign source, don't spend more than 5 lakhs in administrative expenses, right? Friends, we think we are almost over. Then, power of central government to prohibit receipt in certain cases. Yes, the central government has empowered with put restrictions by way of rules to restrict any persons to prohibit receiving of foreign contribution, prohibit any person to take permission, prohibit any person to take intimation. There are 3 things, the law in the FCRA has only 3 things. One is to either to prohibit not to receive, either to prohibit by of prior permission, either way to prohibit by of prior registration, or to prohibit either by of prior intimation, right? So this slide, section 9 says that central government has got the power to notify rules to say that to list out any persons, any category to either to prohibit, don't you receive, do not receive, or to receive by way of a prior permission, or to receive by way of an intimation. There is only a procedural law. Now, these things which you have to study in your, you have from your study material, because a question may be asked. This whole slide, section 11, section 12, section 13, section 14, section 16 deals with procedural aspects regarding to registration by whom. I told you, there is prohibited list section 3, but there are other lists which is permitting associations or organizations dealing in social, economic, cultural, or philanthropic way of do activities. That associations, I told you, they can take either prior permission or they can take either prior registration. This slide speaks about whole procedures regarding to registration of certain persons with CG. Persons having definite cultural, economic, educational, religious or social program shall accept foreign contribution unless such person obtains a certificate. We already told, unless such person obtains a registration, and the procedure for registration is enlightened in section 11, section 12, section 13, section 14, section 16. It is a very direct section. You may study in your home. Don't forget. Fundamentally, you must understand, while giving a certificate of registration or while according registration, the central government prima facie look into the national interest, into the sovereignty of the country, into the protection of the interest of the general public. So finally, we are going to end the session. I told you that either foreign contribution or foreign hospitality, that FC or FH, ultimately it hails from a foreign source. Now the question is, what is foreign source? everything, if you read section 2(1)(j), the definition of foreign source, every foreign source is been categorized as a foreign source. So it's very simple that you can study at your home. I just list foreign government, international agency. There is an exemption for international agency. Don't forget that is UN, especially World Bank, etc., etc. So you have to look into this exemption. I repeat again: government, foreign government, international agency, a foreign company, a corporation, a foreign country, a foreign territory, MNC, a foreign trade union, a foreign trust, a foreign society, a foreign club, a foreign citizen. If you took this slide into your heart, you will understand and you will conclude that every source has been included in foreign source. So the whole law restricts from these slides, right? A foreign contribution or foreign hospitality from this slide or from these sources is the charging of whole, the law of FCRA. So friends, I think I had contributed much. Procedural aspect, you can visit website called fcraonline.nic.in. You should study FCRA Act 2010. You should study FCRA Regulations 2011, amended up to 2019. Form numbers again, I am just listing for information. FC1, intimation for foreign contribution. FC2, intimation for foreign hospitality. FC3A, registration form. FC3B, prior intimation form for relative purpose. You have to be very careful about these. This is with regarding to the society, right? Social, cultural welfare, right? Cultural welfare. Don't forget about this 3 and 3B. This is very important. 3 and 3B. 3B speaks about getting prior. No, I told you again. I want to make you to elaborate more in this video, but still I want to be very clear. Section 3 speaks about restricted list, and we have a list of associations for welfare, social, economic, cultural, educational purpose. They can receive foreign contribution by two methods, right? One is by prior intimation, that is form, that is by prior permission, that is form, FC 3B, and by registration, that is FC 3A. So don't forget 3 and 3B is for society. This is for social, the organization specialized in definite social, cultural welfare activities. This is for individuals basically. This is FC for getting from relative, etc. We already told. FC for foreign contribution, FC for foreign hospitality. Then you have application for renewal of registration, FC3. FC4 deals with annual returns, and FC5 deals with seeking permission with regard to foreign contribution for unregistered persons who are not registered. For registered persons and unregistered, different forms. Forms are not that much important, but being a professional student is better. You have to look into these slides also. The total forms is FC1, FC2, FC3A, FC3B, FC3C. Don't forget FC3A, FC3B and FC3B is with regarding to associations having specific definite social, cultural welfare activities. For other individuals is FC1, FC2, FC4, FC5. So don't forget all these things. All forms, I list again the forms once again: FC1, FC2, FC3A, FC3B, FC3C, FC4, FC5. With this, we will end. So this is the very beautiful law which puts restrictions on accepting foreign contribution or foreign hospitality from a foreign source. So Bilu Balakrishnan is about to sign off from this lengthy video. Don't forget to subscribe my channel Bilu Balakrishnan in YouTube, and press the notification bar so that you will get notifications while I upload a new video. And now from this month I am broadcasting through webcast. There are other webinars are coming, there are other broadcasts are coming, there are other webcasts are coming through my dedicated website for CA law coaching. So you will get the information very soon, and I would request you to visit that portal which will be informed soon, and that will be the one website exclusively dealing with CA law coaching for final stage and for intermediate stage. And the website will broadcast my live classes, my recorded classes, and my webcast, my update session, and also that will be a portal for all information sharing, and that will be the one-stop solution for all the law related topics with regarding to students of CA courses concerned. Stay healthy and take care. Thank you.